In this video, I'm going to be talking about the divorce process in Indiana. I'm going to give you an overview of the process, talk to you about the different documents, and give you examples of the documents that you're going to see through the divorce, as well as give you some ideas on things you should be thinking about if you're considering a divorce. So if you're watching this video, you or someone you know is likely considering divorce or dealing with a divorce. One of the best things you can do is arm yourself with information so you know what to expect in the process. So about me, my name's Nathan Vining. I'm a family law attorney here in Indiana, and I represent people in divorce cases throughout the state of Indiana. By the end of this video, you should know more about the divorce process in Indiana. So the first thing to do when you're learning about divorce in Indiana is break down what is involved in the divorce process. And the divorce case in Indiana, it starts off with filing a petition for dissolution. At the same time, if you have kids or property and you need things to be handled quickly, you can ask for a provisional hearing. And what that is it's a hearing at the outset of the divorce case where the court can make temporary orders as to what should or shouldn't happen with different property, or make custody orders for the kids, temporary child support orders. This is the kind of hearing where one party could ask for possession of the marital residence and things like that. It's to take care of temporary orders and things that would arise when two people are splitting into two different households. Sometimes you need the court to help out and determine what should happen with different property, as well as what should happen with the children. So that's what the provisional hearing is. After you have filed the petition and done a provisional hearing, the next thing in a divorce case typically revolves around discovery. Sometimes you don't need to do discovery in a divorce case, but other times you may need to get information together. Things like the mortgage statement, house appraisals, retirement records, and you need to go through all those things and value the different assets in your divorce to determine what is going to go into the marital estate. You may also need to do different discovery around children-related things as well. After you've performed discovery, a lot of times, and a lot of courts in Indiana would require mediation. What mediation is it's a settlement conference between the parties. It's where you would meet with a third-party mediator who is a neutral, who would go between the parties and talk about what they want to see in a settlement and see if there's a way that a settlement could be reached in your case. Some cases don't need mediation. It depends on how much court time would be needed to hear the case, as well as the different counties and courts throughout the state. Every court operates a little different with regards to mediation requirements. And the last step really is taking steps to resolve the case. You can settle the case through mediation. You can also work among yourselves, reach an agreed settlement, or you can request the court for a final hearing and resolve any contested issues at a final hearing. And that would be a very high-level overview of the divorce process in Indiana. Those are kind of the 5 big steps. So what we're going to talk about next is the different documents that you're going to see if you're going through a divorce. So the starting documents, really, the things that you're going to see at the outset of the case are things like the petition, basic things like the summons, provisional orders with needed. And then a lot of times if you have a provisional hearing, a lot of local rules will require that you submit a child support worksheet and a financial declaration. And I'm going to walk you through and talk about what these different documents are and show you examples of what these documents are. So starting with the divorce petition, Indiana Code 31-1525 sets out what is required in a divorce petition, and it says that it must be verified. It has to state the residence of each party, the date of the marriage, the date of separation, the names, ages, and addresses of any children under 21. It states the grounds for dissolution of marriage. And it's important to note that Indiana is a no-fault state, and a lot of times what that means is that in the divorce petition you would allege that there's been an irretrievable breakdown of the marriage. And you're also going to request an F, the relief sought, which that's what you're going to be requesting the court do after you file the petition. So those are the basic requirements of the divorce petition. So as an example, I'll give you an example here, is something I created for John Doe and Jane Doe. This is a sample of what an Indiana divorce petition would look like. Here at the top is what's known as the caption in a case. He's providing the respondent's address, the date of marriage, the date of separation, and then if there's children, you would need to indicate how many children you have, names and dates and births and address of the children, also alleging that the respondent's not pregnant, and then the grounds, which is the marriage between the parties is irretrievably broken. So that's a simple divorce petition. It's also important to note that it's verified, which means that you would affirm under the penalties of perjury that these representations are true, and what you're doing is stating to the court that you have a case for a dissolution of marriage, you're meeting the jurisdictional requirements, and you're requesting that the court would dissolve the marriage. So that is a sample divorce petition for an Indiana case. The next thing that you would see in a lot of cases is the request for a provisional hearing. And what that is the provisional hearing, like I said, it's the hearing at the outset of the case to determine what should happen with property, children, any temporary issues where you may need the court's involvement to work things out. So the statutes here that I have on the screen, 3115, 4, 13, 14, and 15, kind of talk a little bit about what a provisional order is. It's important to note that a provisional order is temporary and it terminates when the divorce decree is entered or if the parties resolve their differences and dismiss the divorce. It's also important to note that it can be, in section 15, that can be revoked and modified before the final decree, because sometimes there's different things that could happen with property or the children that would require that you go back to court to get an order on different matters. And here is Indiana Code 3115.4.1, which states that essentially either party at the beginning of the divorce can file this motion, and it's for temporary maintenance, temporary child support, possession of property. You could request counseling or even different protective orders to stop the parties from selling or removing any property from marital residence. So this statute, 3115.4.1, sets out the procedure to obtain a provisional order as well as what types of things can be included in provisional order. So next I'm going to show you a sample of what a provisional motion looks like, or a motion for provisional orders, and you can see one here. This is a simple one with the marriage of John Doe and Jane Doe. You have the caption that's the same as in the divorce case, and then it basically indicates that the petitioner, John Doe, is coming before the court and requesting that the court enter provisional orders determining custody, visitation, and child support, and then requesting that it enter orders regarding the maintenance and possession of property during the pendency of the action. So the provisional order can be the request for provisional orders can be pretty simple. It basically is indicating the court what you want to see happen. So in this case where they had kids, it's requesting the court determine the issues of custody, visitation, and child support, as well as make orders with regards to the different possession of different property throughout the pendency of the action. And then it's also verified under the penalty of perjury, and then he would also have to sign this. So that's basically a sample motion for provisional orders. There's also two other documents that you're going to see when you file the divorce case. There's the appearance. A lot of times the attorney will file an appearance. So here would be the attorney, which would be me, indicating that he's appearing for the petitioner John Doe, and it lists out different information so the courts know how to contact the party that's starting the case. And then you're also going to see a summons at the start of a divorce case. And here you have the same caption, and it's the state of Indiana to the respondent Jane Doe. It's going to list her address, and it's just basically what the sheriff or the court would serve this person when starting the case. And what it's going to say is that you've been sued in the above court, the petition is attached, and it's indicating that they need to take an affirmative response, otherwise the court may take a default action after the expiration of 60 days. So this would be a sample summons, and that's also going to have to be filed along with the divorce petition, appearance, and potentially a motion for provisional orders. So after you filed the documents to start the case, there's going to be things that you're going to need to develop in a divorce case. There's discovery. A lot of times if there's property that needs distributed in a marriage, you're going to need to develop a balance sheet, which is a document that can lay out the value of different assets that you have and indicate how much they're worth, what debts are there, and who should get each asset or debt. And it's a way to try and balance the marriage to come up with that 50-50 pot or 60-40 or whatever you're going to be trying to determine at a final hearing. And then a lot of times if you have children, you may need to develop a parenting calendar or journal if needed to help keep evidence as to what's going on in your case. Are pickups and drop-offs working, or are there issues that may need to be dealt with at a final hearing? You're going to want to keep that information in a journal so you can use that as an exhibit. So when it comes to discovery is basically the process of gathering information. You can do it through requesting documents or asking specific questions that the party would have to answer under oath. And a lot of times discovery is going to be asking things about income information, financial information of the parties, things about different assets, as well as custody and child related information. You're going to want to start learning what the other party's ideas are for custody. Is there room for agreement? Are there concerns about the other party? And do you need to do discovery about custody or child related information? To start going into what some of these other things are, I'll show you what the financial declaration is. And that's one of those documents that could be needed at the beginning of the case. A lot of local rules, it's different county by county, but a lot of local rules would require that you file a financial declaration before any contested family law hearing. And this is what this is. This is a sample of the Marion County Financial Declaration, and it has the same caption with the parties' information. And then what it does is it goes through basically a lot of the different things with regards to income, assets, monthly expenses, to give the court and the other party a broad financial overview of the other party. So here it's their salary, weekly income. It takes deductions for health insurance, child support, child care expenses, and then it goes through and lists out those monthly expenses. So you can see things like taxes, rent, maintenance on residence, gas, life insurance. It really contemplates just about everything and has room to even include other expenses. So the court and the other party, and as well as yourself, can get a good understanding as to your broader financial picture. And even in a divorce, it's more important. It goes down and lists your assets. You can see what you and the other party are looking at in terms of a broader balance of the divorce. So you can value household furnishings, vehicles, bank accounts, real estate. It gives you a broad overview of the other party's financial picture. The other thing that you may need to develop at a provisional order would be the child support worksheet. And this is something I recommend people, if you're involved in a divorce or custody case that involves child support, I recommend that people get comfortable with a child support calculator. You can find it online by Googling it's Indiana Child Support Calculator. I'll also have a link at the bottom of the video. But you have two sections for parents and for practitioners. You basically can go in here and it'll walk you through the math and ways to develop a child support calculation. So to give you an example, I just did a basic worksheet for John, Joe, and Jane Doe. I just put basic income information. So you basically would put in the income of both parties. You're going to calculate the overnights of each parent because parenting time is a factor in the child support calculation. You're going to look at whether or not there's subsequent children, whether a party is paying court-ordered child support for another prior born child, whether there's a legal duty to support another child. You're going to look at, is there any alimony or maintenance paid to the other party? You're going to look at, is there any child care that's being paid, as well as health insurance. So this is a basic calculation. It's similar to what you'd see in a lot of cases here. There's one child, there's the income, the overnights, there's a child care expense and a health care expense. And what that does is it gave the figure of $65 a week child support. And then we would create the documents, which is a formal child support worksheet. This is the worksheet here. You can see this just runs through the math and it shows the child support obligation is $65 a week for John and Jane Doe with their one child. And here you can see their incomes, the child care, and the health care. And then ultimately it puts out that child support obligation is $65 a week. So a lot of times if you're going to be going to a provisional hearing or even a final divorce hearing, this child support worksheet is going to be a document that needs to be generated. Another document that also needs generated through a divorce case could be a parenting time journal. And I'm going to walk you through what one of those could look like and how to create one for yourself. Because if you are in a divorce involving children, it's important to take notes on this stuff. Even if you're getting along and you don't think it's important now, it's good to get in the habit of keeping good records, just because it helps the parties to be organized and it helps you to gather information in case there's problems in the future. So you can show if there's a pattern of a long-term misconduct by one party, and it's a story to tell rather than just saying, well, they missed parenting time a lot. It's better to be more specific so you can point to when parenting time was missed and give examples as to how many days and what exactly occurred in your situation. So here's an example. A lot of times too, I recommend, this is a website, Custody Exchange. I'll give you a link in the bottom of the site. But I first also, if you're going through divorce, recommend taking a look at the different parenting time schedules available. There's a lot of different ways to do it. There's 50-50 schedules, 60-40 schedules, 70-30. The way you can split parenting time is basically limitless, and every family is different. So you're going to want to come up with a schedule that fits your family. So I recommend looking at a site like this to just see what's out there and look at whether there's options that maybe you would suggest or recommend or want to argue that should happen in your situation. So get familiar with these kinds of schedules and think about what you want in your situation. Once you do that, I would then generate a calendar based on what the court has ordered in your case or what you're actually doing for parenting time on this same website. You can actually go through and go to a calendar and generate a schedule that reflects what your parenting time schedule would look like, and you can print it out. And then on each of these days, keep notes as to, if you have a exchange on Friday the 15th and a party's late, write down on there exactly what happened, or if there was a phone call or evidence that you need on any specific day that you need to remember, write it on that calendar, and that's a good way to keep a parenting time journal. Discovery is also important in divorce, and as an example, just to show you what I mean by discovery, here's an example of what I'm talking about. Here's what's known as a first request for production of documents. Under the Indiana trial rules, if you're a party to a civil case, you can request information from the other party. Particularly, you can request documents. So in a typical divorce case, this would be an example. So here, John Doe's requesting that Jane Doe produce this information because he needs to start getting his evidence that he needs to for the divorce. And a lot of times in a divorce, you're going to request the other party's tax information. You're going to request, a lot of times, you're going to request bank information, different account statements from the bank. A lot of times you may need life insurance policies. You're going to want to see evidence of what debts that they would have. So the request for production of documents is a way to get information to see the financial breakdown of the other person and do your own due diligence to review those documents to see if what they say on their financial declaration actually matches up to what's in these documents. So you're going to want to do discovery around things like the taxes, income, debts, and then even the last one, what exhibits they would intend to use at a hearing, so you can see what evidence they intend to introduce at any trial. So discovery, the request for production is a good way to start getting information in your case. The other type of discovery that you see in a divorce would be interrogatories, and what those are questions that you would ask the other party under oath. And here's an example of what you would see in a divorce case. Here it lays out the duties, the definitions in terms of just what these things mean in the document, but a lot of times you could do discovery around financial information. So here you can ask them information about different assets, whether or not they believe there should be a 50-50 split in the marital pot. If they don't, why do they think that there shouldn't be a 50-50 split? You could even ask information about custody and things like, what do you want to see happen with legal custody and physical custody and parenting time? So interrogatories are a way to start asking questions to see if there's issues that you guys could agree on or get evidence that you could use at a contested trial. And then at the end of the interrogatories, the other party would have to do an affirmation and swear under the penalties of perjury and sign that to indicate that the information that they're stating in these are true. And if you are responding to something like this, a lot of times your attorney would state various objections to different questions being asked to maybe prevent information from being disclosed or protect you in different ways. So if you're responding to discovery, either request for protection or interrogatories, it's important to consult with an attorney. And the last document I'm going to talk about that you would see in the middle of a divorce would be a balance sheet. And this is something if I get a call from a divorce prospect and they're considering divorce and they're starting to work through the issues and different things that you would assign value to that you think needs to be included in the marital pot, you would want to start listing this in this balance sheet. So here you have the household possessions, the value, and then you can even list out in the columns, you have the husband column and the wife column, who gets what property. So here, household furnishings, you could list out cars, you would have the value of the car, the amount of the debt, the equity, and then assign it to each different person. And it goes for everything. It goes to securities, bank accounts, retirement accounts, the marital residence, here the value of the marital residence, the debt, the equity, and at the bottom, after you've assigned values to the property to the different parties, you could list out sum that each party is receiving to see if it's close to a 50-50 split, or if not, what needs to happen. So here you can see the husband is getting less than the wife, and specifically there would need to be some kind of there's a $24,500 difference between what each party is getting in the balance of the divorce. So there could sometimes need to be an equalization payment of that amount from the wife to the husband to help make up that difference, and that can be done through refinancing a house or a lot of other different ways. But it's important to start working through a balance sheet to start determining what assets are there, what debts are there, and how should everything be split up in the divorce. So we've now went through some of the things that you see in the middle part of the case: the discovery, the balance sheet, working out child support obligations, working out the financial declaration. Once you believe you've obtained all the different information, there comes a point where you need to figure out how are you going to settle a divorce. One important thing to know about divorce in Indiana is that it's not granted automatically or at the outset of a case. There's what's known as a cooling off period in Indiana. You have to wait 60 days from the filing before you can petition the court for a final dissolution hearing. And the authority for that set out in 35-15-210, which states that a final hearing shall not be conducted earlier than 60 days after the filing of petition. The reasoning behind that is that there's a lot of times where people may reconcile before the divorce is over, so this legislator put in place this cooling off period before a divorce can be finalized. So let's say you've filed a divorce, you've done the discovery, you have your information together, and you're looking to finalize your divorce. There's a couple options. One of the first would be attending mediation. Mediation would be a settlement conference with you, your counsel, if you have counsel, the other party and their counsel, and a third party neutral who would go back and forth between the parties and see if they can negotiate an agreement on your behalf. So what I'm going to show you is what a request for mediation looks like. Here you can see in the John and Jane Doe divorce, they believe mediation could be beneficial for the divorce. A lot of courts would require it if you're going to need a hearing for more than an hour, and even a lot of local rules and counties have programs in place that really promote mediation. So here you can see they're requesting the court issue a panel of mediators. A lot of counties, if you request mediation, will name 3 mediators that the parties can choose from. So each party would get a chance to strike one of those mediators from the list, and ultimately it would leave one mediator who would be the mediator for this case. So here they're representing that the final hearing would exceed an hour. They believe the parties would benefit from mediation, and they're requesting the court order parties to mediation and issue a panel for the court to consider. So that is an example request for mediation. So let's say you attended mediation and it didn't work out, but over time maybe you can come to an agreement on the things you didn't agree on at mediation. Or before mediation even, maybe you can get with the other party and their attorney and see if you can work out a deal. That is something that's allowed under Indiana law. A lot of divorces, and even most divorce cases, are resolved by settlement. And this statute here outlines the process for doing that. You have to have a written waiver by both parties at the final hearing. So both parties have to say, we want to waive our right to a trial, and you have to then indicate to the court that there's no further contested issues, and then you also have to let the court know that you have made an agreement that is in accordance with Section 17. So we're going to take a look at Section 17 here. With Section 17, you can see that the Indiana law is trying to promote settlements of divorce. So it allows the parties among themselves or their attorneys to work out the different issues. It could be maintenance of the parties, the distribution of property, or even custody and support of the children. So pursuant to Indiana Code 3115-2-17, you can settle your divorce at any time and then have that settlement agreement filed and receive a summary dissolution decree after those 60 days. So one of the ways you can file your divorce is through mediation. The second would be through just working out a property settlement agreement on your own. I'm going to show you a sample of what this would look like. Here is a sample final settlement agreement for an Indiana divorce. So keeping the same theme here, you can see the caption, and then it goes down and it recites things that are included in the decree. It's the date of marriage, date of separation, includes children information, includes information about the case, and then it also includes what's important here is the waiver of final hearing. It says the parties here waive the right to a final hearing to represent that this agreement settles any and all contested issues arising out of the dissolution of marriage. So you can then go through and see what this agreement is. It first sets out property settlement rights here. It can take care of things like how you want to split up personal property and household goods. It can take care of intangible property like bank accounts, investment accounts, retirement accounts. It can account for distribution of your vehicles, and even real property. It can talk about who gets what property. It can talk about will one party get it or the other, and if one party keeps the property, do they need to refinance it or do anything to take the other person off the loan or the debt or even the title. It also covers debts, and then child-related issues. You would need to work out things like joint legal custody, parenting time, child support, what's going to happen with health care, child support arrearage. And then another thing a lot of people forget is tax exemptions. It needs to specify what happens with the children in each tax year, who's going to claim the child for taxes. And this is a very common setup, is that the parties with one child would alternate the right to claim the child with for taxes, with one party claiming even years and one party claiming in odd years. And then at the end, it's just a lot of miscellaneous provisions, like each party paying their own attorney's fees. They're representing the court that they've had a chance to analyze the other person's assets and that this is a settlement of everything that's contested between the parties at this time, and that they're doing it voluntarily. And then at the bottom, there's an affirmation, and then each party signing it and their attorney. So that's a simple settlement agreement for an Indiana divorce. There's also what's known as the decree. This is what the judge would then sign if presented with the settlement agreement, and you would also need to present this proposed decree. And what this is a simple one, but they're saying, the jurisdiction allegations are true, the residency requirements have been met. What this means is that this court has authority to issue the divorce. They're stating the 60 days have passed so that it's also ripe to be concluded. And then it can go through, and the court's finding that the parties have waived their right to a final hearing. They're finding that they've entered a settlement agreement. And in this one, the court's finding that it should accept the final settlement agreement. It's important to know that the court actually reviews these, and a lot of times, if it's not done appropriately or isn't accounting for the Indiana law correctly, can reject the agreement and send it back to the parties to rework and fix any issues that there could be. So this is a simple dissolution decree, and this is one of the avenues to settle a divorce case. The first would be through mediation, another would be through reaching an agreed settlement among the parties. And then what we're going to talk about last is requesting a final hearing. So if you're unable to reach an agreement through mediation or through negotiation amongst yourselves, the last way you can finalize divorce would be through requesting a final hearing. And here's an example on how you would request a final hearing with the court. It's important to note, though, that if you go to mediation and you're trying to settle, you don't have to reach an agreement on all issues. You can actually reach a partial settlement on the issues. So for instance, maybe you agree on everything but how the taxes for the children should be handled. You could request a final hearing on only that issue and tell the court that you're stipulating to an agreement on all these other issues. So you can work out a lot prior to a final hearing and then go to a hearing on only part of the issues, or you can request a final hearing over everything. And here's an example on how you'd request that from the court. It would just basically, this document, similar to all the others, has the same caption at the top, and then it's stating that the requirements that need to be met before a final hearing can be held are done. So here you're saying that the petition's been filed, 60 days have passed, and then that the parties have completed the mediation requirement, which was not successful. A lot of courts do require mediation, so when you request for a final hearing, you're going to want to tell them that we tried this and it wasn't successful. So that is a simple request for a final hearing. So what we just went over is an overview of a lot of the different documents that you're going to see through the Indiana divorce process. You have the petition for dissolution, the provisional orders, the financial declaration and discovery documents, all the way through the settlement agreement, summary decree, and request for final hearing. This is intended to be an overview of what the process looks like, as well as what kind of documents you're going to see along the way. And it's important to know this kind of stuff so you can be thinking in the middle about what you can be doing to prepare. Is there information that you could be gathering to get to your attorney? Or even if you're contemplating divorce, this can help you see exactly what the process is so it can be a little bit more predictable and hopefully a little less stressful for you. So it's also important to note, though, that what we just went over is just a very simple overview. This would be for a simple kind of a divorce. The process can be a lot more complicated than what I just showed you alone. There can be things like business valuations where you may need to get an expert involved to value a business. Sometimes there's issues with safety and you need to get protective orders, or there could be issues with somebody that's removing property or selling property before the divorce is final. So you need to get immediate court orders to prevent that. Custody can also be challenging. There can be challenging custody issues, or even there can be uncooperative parties. Sometimes you may need to get the court involved to actually get information from the other party. Also, there can be hidden assets, hidden income. The list goes on and on. And it's important to note that divorce can be very complicated. So if you're sitting here and you have questions, you should get help from an attorney, because this is something you shouldn't do alone. So as you're going through this, as you're coming up with questions, write them down, create a list, and start to get those questions answered, because arming yourself with information is one of the best things you can do in this process. So again, my name's Nathan Vining. If you have questions about Indiana divorce, you can give me a call or text me. I'd be happy to help answer any questions you have. If we have a consultation, we would walk you through a lot about what the process would look like, as well as start to identify some of these things that you need to be thinking about along the way, so you have homework on things you can be doing to help yourself. If you have other questions, you can also watch more YouTube videos. I have a lot more information on Indiana divorce on YouTube as well as my website, and would be happy to help.